House come to order. First order of business is roll call. Clerk will unlock the machine and the members will record their presence. The things we do for District 22. Has every member recorded their present good gentleman from 22? Clerk will lock machine.
Barbieri.
Oh, Barbieri, wake up. We missed anybody else? Clerk will lock the machine and record the roll. 62 ayes, 8 absent and excused, the majority being present at the House is now ready to do business. House will now advance to second order of business, prayer by our good chaplain Tom Doherty, followed by the Pledge of Allegiance from Three Creek Chantry Bracket. Will our friends in the gallery please arise?
Well, you all should be smiling today. You had a great caucus yesterday, and it's Pie Day. Pie Day today, fourth floor, to be rewarded for it. Yeah. Anyway, Franklin Delano Roosevelt said this: take a method and try it. If it fails, admit it frankly and try another. But by all means, try something. And then the passage of scriptures, for a long time Israel was without a true God, but in their distress they turned to God, and the leaders were told this in 2 Chronicles 15:7. Be strong and do not give up, for your work will be rewarded. And I tell you today, be strong, do not give up, for your work will be rewarded. Let's pray. Dear Heavenly Father, I read in the Old Testament often how you instructed your leaders. You knew, O Lord, what you had for them, and if they would listen, they would be rewarded. I pray, O Lord, that we would take to heart this day the words shared in this passage, to be strong and not to give up. May these words ring out in our hearts as we go through every day. Give us your strength to move forward and to always move forward in a way that would open the doors for all to see the value of what needs to be done. When we see red lights before us, help us to stop and look both ways before proceeding. You have blessed our leaders with minds to discern right from wrong and for proceeding forward in a thoughtful, positive way. I pray we continue to work together in one accord and truly adding to the value of this state. Thank you, Lord, in Jesus' name. Amen.
I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
House will be in order. The House will now advance to third order of business, approval of the journal. The House is at the third order of business.
In the House of Representatives, February 7th, 2024, Mr. Speaker, we, our Committee on Judiciary, Rules, and Administration, report that we have read and approved the House Journal of the 30th Legislative Day and recommend same be adopted as corrected. Moved by Skog, seconded by Gannon.
You've heard the motion. All those in favor say aye. Those opposed say nay. The motion passes and the House Journal is approved. The House will now advance to fourth order of business, consideration of messages from the Governor and the Senate.
From the Senate, February 6th, 2024. Mr. Speaker, I transmit herewith Senate Bills 1244, 1235, and 1251, which have passed the Senate. Novak, Secretary of the Senate.
Senate Bill 1244, 1235, and 1251 will be filed for the first reading calendar. The House will now advance to fifth order of business, report of standing committees. The House is at the fifth order of business.
In the House of Representatives, February 7th, 2024. Mr. Speaker, we, our Committee on Judiciary, Rules, and Administration, report that we have printed House Bills 478, 479, 480, 481, 482, 483, 484, 485, 486, 487, 488, 489, and 490. Skog, Chairman.
House Bill 478 and 479 were referred to the Business Committee. House Bill 480 and 481 were referred to the Commerce and Human Resources Committee. House Bill 482 and 483 will be referred to the Judiciary and Rules Committee. House Bill 484, 485 were referred to the Resource and Conservation Committee. House Bill 486 and 487 were referred to the State Affairs Committee. House Bill 488 were referred to the Revenue and Taxation Committee. and House Bill 489 and 490 referred to the Health and Welfare Committee.
February 6th, 2024. Mr. Speaker, we, your Committee on Agricultural Affairs, report that we have had under consideration House Bill 403 and recommend that it do pass. Andrus, Chairman.
House Bill 403 will be filed for the second reading calendar.
February 6th, 2024. Mr. Speaker, we, your Committee on Local Government, report that we have had under consideration House Bill 444 and recommend that it do pass. E. Hart, Chairman.
House Bill 444 will be filed for the second reading calendar. Without objection, the House now advances to eighth order of business. Introduction, first reading, and reference of bills and joint resolutions. The House is at the eighth order of business.
In the House of Representatives, House Bill 491 by Local Government Committee, an act relating to municipal corporations, amending Section 501306A Idaho Code to provide that certain notice may be given by first class or certified mail, to provide for proof of mailing and to make technical corrections, and declaring an emergency and providing an effective date. House Bill 492 by Local Government Committee, an act relating to development impact fees, amending Section 678204A Idaho Code to provide that recreation districts may enter into certain intergovernmental agreements, and declaring an emergency and providing an effective date. House Bill 493 by State Affairs Committee, an act relating to mask mandates, amending Chapter 23, Title 67 Idaho Code by the addition of a new Section 672360 Idaho Code to establish provisions regarding the prohibition of mask mandates, to define terms, and to provide exemptions, and declaring an emergency. House Bill 494 by Judiciary, Rules, and Administration Committee, an act relating to crimes and punishments, amending the heading for Chapter 56, Title 18 Idaho Code, repealing Section 185601 Idaho Code relating to interstate trafficking and prostitution, amending Chapter 56, Title 18 Idaho Code by the addition of a new Section 185601 Idaho Code to define terms, amending Section 185602 Idaho Code to revise terminology and to make a technical correction, amending Section 185603 Idaho Code to revise terminology and to make a technical correction, amending Section 185604 Idaho Code to revise terminology and to make a technical correction, amending Section 185605 Idaho Code to revise terminology and to make technical corrections, amending Section 185606 Idaho Code to remove definitions and to make a technical correction, amending Chapter 56, Title 18 Idaho Code by the addition of a new Section 185607 Idaho Code to provide for the crime of interstate trafficking and commercial sexual activity, amending Section 185608 Idaho Code to revise terminology and to make a technical correction, amending Section 185609 Idaho Code to revise terminology, amending Section 185610 Idaho Code to revise terminology and to remove terms, amending Section 185611 Idaho Code to revise terminology, amending Section 185612 Idaho Code to provide code references, repealing Section 185613 Idaho Code relating to prostitution, amending Chapter 56 Title 18 Idaho Code by the addition of a new Section 185613 Idaho Code to provide for the crime of providing commercial sexual activity, amending Section 185614 Idaho Code to revise terminology, to revise provisions regarding soliciting commercial sexual activity, to provide a penalty and to make technical corrections, amending Section 185620 Idaho Code to revise provisions regarding forfeiture and to make technical corrections, amending Section 185621 Idaho Code to revise a provision regarding preservation of property and to make a technical correction, repealing Section 188602 Idaho Code relating to definitions, amending Chapter 86 Title 18 Idaho Code by the addition of a new Section 188602 Idaho Code to define terms, repealing Section 188603 Idaho Code relating to penalties, amending Chapter 86 Title 18 Idaho Code by the addition of a new Section 188603 Idaho Code to provide for penalties, amending Section 188604 Idaho Code to revise a provision regarding restitution, repealing Section 188605 Idaho Code relating to human trafficking victim protection, amending Chapter 86 Title 18 Idaho Code by the addition of a new Section 188605 Idaho Code to authorize the Attorney General to take certain actions, amending Section 188608 Idaho Code to revise provisions regarding safe harbor provisions, amending Chapter 86 Title 18 Idaho Code by the addition of a new Section 188607 Idaho Code to provide for the crime of human sex trafficking, amending Chapter 86 Title 18 Idaho Code by the addition of a new Section 188608 Idaho Code to provide for the crime of human sex trafficking of a child, amending Chapter 86 Title 18 Idaho Code by the addition of a new Section 188609 Idaho Code to provide for the crime of human labor trafficking, amending Chapter 86 Title 18 Idaho Code by the addition of a new section 188610 Idaho Code to provide for the crime of human labor trafficking of a child, amending Chapter 86 Title 18 Idaho Code by the addition of a new section 188611 Idaho Code to provide that certain property shall be subject to forfeiture, amending Chapter 86 Title 18 Idaho Code by the addition of a new section 188612 Idaho Code to provide for an inventory of seized property, amending Chapter 86 Title 18 Idaho Code by the addition of a new section 188613 Idaho Code to provide for a forfeiture request and a rebuttable presumption, amending Chapter 86 Title 18 Idaho Code by the addition of a new section 188614 Idaho Code to provide for preservation of property, a warrant of seizure, and protective orders, amending Chapter 86 Title 18 Idaho Code by the addition of a new section 188615 Idaho Code to provide for an institution of proceedings, amending Chapter 86 Title 18 Idaho Code by the addition of a new section 188616 Idaho Code to provide for forfeiture of personal property and rights of third parties, amending Chapter 86 Title 18 Idaho Code by the addition of a new section 188617 Idaho Code to provide for forfeiture of real property and rights of third parties, amending Chapter 86 Title 18 Idaho Code by the addition of a new section 188618 Idaho Code to provide for proportionality, amending Chapter 86 Title 18 Idaho Code by the addition of a new section 188619 Idaho Code to provide for a bar on intervention, amending Chapter 86 Title 18 Idaho Code by the addition of a new section 188620 Idaho Code to provide for jurisdiction and depositions, amending Chapter 86 Title 18 Idaho Code by the addition of a new section 188621 Idaho Code to provide for disposition of property, amending Chapter 86 Title 18 Idaho Code by the addition of a new section 188622 Idaho Code to provide for forfeiture of substitute property, amending Section 161602 Idaho Code to provide correct code references, amending Section 187803 Idaho Code to revise the definition and to make a technical correction, amending Section 188303 Idaho Code to provide a correct code reference, amending Section 188304 Idaho Code to provide correct code references, amending Section 188502 Idaho Code to provide correct code references, amending Section 195602 Idaho Code to provide a correct code reference, amending Section 331208 Idaho Code to revise terminology and to provide a correct code reference, amending Section 391113 Idaho Code to provide correct code references, amending Section 49335 Idaho Code to provide a correct code reference, amending Section 673014 Idaho Code to provide correct code references, and declaring an emergency and providing an effective date. House Bill 495 by State Affairs Committee, an act relating to advertising illegal products and services, amending Title 18 Idaho Code by the addition of a new Chapter 89 Title 18 Idaho Code to prohibit the advertising of illegal products and services, amending Section 194705 Idaho Code to provide for the apportionment of certain fines and declaring an emergency. House Bill 496 by State Affairs Committee, an act relating to property in general, amending Section 55103 Idaho Code to revise the definition and declaring an emergency and providing retroactive application. House Bill 497 by State Affairs Committee, an act relating to public office, amending Section 59901 Idaho Code to revise provisions regarding vacancies in public office and providing an effective date. House Bill 498 by State Affairs Committee, an act relating to liability for publishers and distributors of material harmful to minors on the Internet, amending Title 6 Idaho Code by the addition of a new Chapter 38 Title 6 Idaho Code to provide legislative findings and intent to define terms to prohibit the intentional publication or distribution of material harmful to minors on the Internet, to provide for a private cause of action, to provide affirmative defenses, to provide for venue for civil actions, to provide for the exclusivity of private civil enforcement, to provide for certain immunity and limits on state court jurisdictions, and to provide for severability and declaring an emergency and providing an effective date. House Bill 499 by Health and Welfare Committee, an act relating to the Idaho Dietary Supplement Act, amending Title 37 Idaho Code by the addition of a new Chapter 35 Title 37 Idaho Code to provide a short title to provide that the production, marketing, distribution, sale, and use of dietary supplements in compliance with certain laws and regulations shall be legal in Idaho, and to define a term and declaring an emergency and providing an effective date.
House Bill 491, 492, 493, 494, 495, 496, 497, and 498, and 499 were referred to the Judiciary and Rules and Administration Committee for printing.
In the Senate, Senate Bill 1244 by Judiciary and Rules Committee, an act relating to elections, amending Section 1823-18 Idaho Code to prohibit electioneering at certain polling places, to provide certain exceptions, to provide provisions for enforcement, and to revise provisions regarding penalties for violations and declaring an emergency. Senate Bill 1235 by State Affairs Committee, an act relating to public library district trustees, amending Section 332715 Idaho Code to revise provisions regarding the terms of office for public library district trustees, amending Section 332718 Idaho Code to revise provisions regarding the terms of office for public library district trustees using trustee zones and providing an effective date. Senate Bill 1251 by State Affairs Committee, an act relating to election campaign contributions and expenditures, amending Section 676602 Idaho Code to revise a definition and declaring an emergency.
Senate Bill 1244, 1235, 1251 will refer to the State Affairs Committee. Without objection, the House will now advance 10th order of business. Second reading of bills and joint resolutions. The House is at the 10th order of business.
February 7th, 2024, House Bill 475 by Appropriations Committee regarding Appropriations Legislative Branch, House Bill 424 by Business Committee regarding Community Resident Associations, House Bill 445 by Revenue and Taxation Committee regarding taxes, House Bill 449 by Revenue and Taxation Committee regarding property taxes, House Bill 450 by Education Committee regarding school district activity funds, House Bill 452 by Education Committee regarding education, House Bill 454 by Education Committee regarding advanced opportunity scholarship, House Bill 435 by Health and Welfare Committee regarding uniform controlled substances.
House Bill 475, 424, 445, 449, 450, 452, 454, and 435 will be filed for the third reading calendar. The House will now advance to 11th order of business, third reading of bills and joint resolutions. The House is at the 11th order. Good lady from 8.
Thank you, Mr. Speaker, for a privilege and a motion, please.
Good lady has the floor for a privilege.
Okay, for a privilege, I just want everybody to be aware what we're going to do. I'm going to hold 2 bills, you're going to see in just a minute, and then we're just going to run through the calendar until we hit lunchtime. So that's the plan, so just be aware of that. So, Mr. Speaker, I ask unanimous consent that we hold House Bill 411 and House Bill 458 for one legislative day on the third reading calendar.
Thank you, good lady. You've heard the motion, the unanimous consent motion to hold House Bill 411 and 458 on the third reading calendar one legislative day. Is there an objection? Hearing none, so ordered. The bills be held on the third reading calendar, and the House will now have in consideration House Bill 421. Good lady from 30.
Thank you, Mr. Speaker. I ask unanimous consent that we dispense with further reading of House Bill 421.
Unanimous consent has been requested. Is there an objection? Hearing none, the good lady has the floor. Present the bill.
Thank you, Mr. Speaker. Good ladies and gentlemen, House Bill 421 gives us the opportunity to answer for ourselves a question. The question is, are sex-based distinctions in the law appropriate and beneficial, or are they harmful instruments of oppression which should be undefined and erased? This is a debate which is going on in the culture around us. And it is evident, given the testimony that we have heard, that there are some in society who believe that biology-based definitions of male and female are, by virtue of their very existence, harmful. If we accept this premise and carry it to its natural conclusion in state policy, the result is a loss of protected private spaces for females, including changing rooms and restrooms. The loss of sex-based separations in our prisons, our state hospitals, and our domestic violence shelters, and the end of sex-based separations in athletics, among other things. It means that the category of sex in our vital statistics records, which inform our understanding of certain trends in society, as well as on our driver's licenses and other places, become meaningless. If we accept that a biology-based understanding of sex as a category is discriminatory, it also becomes impossible to establish meaningful biology-based distinctions in medical records, in insurance policies and practices, and it will significantly impact healthcare, law enforcement, and family law cases, in addition to efforts to protect women as a class in ways that we have only just begun to understand. How has this happened? There has been no formal discussion on the floor of this body to abandon sex-based distinctions in the law. And yet, it is evident to me from the conversations that I hear around me as a woman and a mother and a legislator, that in the minds of some, this is happening. This is happening in part because we, the legislative body, the ones responsible to define terms in the law, have continued to operate over many decades without a real, substantive, biology-based definition of male and female in the law. In spite of the fact that we rely on sex-based terms throughout our state code. In fact, we have 133 references using the word mother in state statute, 147 references to father, 88 references to female, and 54 references to male. In each of these instances, the authors of this legislation chose a term based on an assumption that there was a biology-based premise, a reason that this term was placed in that particular statute. In light of some of the conversations happening around us and some of the things happening in the court, I believe that it is time to no longer be silent about what this body intends when we use a term like male or female in the law. And so House Bill 421 provides a basic biology-based definition of these terms. It's pretty simple. Males produce sperm, females produce eggs. That's basic biology. But then you'll see that the definition also takes into account that as human beings, we change over time. And so you see in the definition the terms has, had, or will have. You'll also notice that these definitions take into account the reality that in an imperfect world, there are developmental or genetic anomalies or historical accidents which do happen and which can make it difficult to distinguish the sex of an individual. And so we have the language or would have but for, which takes that into account. It is true that rare disorders of sexual development do occur, and so I'm going to open with briefly addressing that because I suspect that it may come up. This does not mean that there's still not two biology-based distinctions here. There's still two gametes, there's still male and female, and if we were to use biological terms to describe human beings, we would say that we are all bipeds. We have two legs. But there certainly are people in this world who, but for, to use the language of the bill, a developmental or genetic anomaly or a historical accident no longer have two legs. But they're not a new kind of human. They're still people, and people still have two legs. These rare exceptions need to be taken into account in the policy that we write. You'll see that this bill includes 3 other sections of code where we have an existing definition for biological sex. These sections have been included in this definition, or in this legislation, because when we define male and female clearly and distinctly, and then tie that to biological sex, it gives us a more reliable definition. But you will notice that in these sections of code, we have already addressed in the policy how we approach these rare exceptions. And that is what we should do as we proceed forward in our policy, is take into account those rare exceptions. So, in closing, without a clear understanding of what language means, it becomes very difficult to have an intelligent conversation about our intentions. And so I invite, or I would say in addition to having an intelligent conversation, provide the protections that are important. And so with that, I'm happy to stand for questions and invite your support for House Bill 421.
Thank you, lady. You've heard the motion. Is there further debate on the motion? Hearing none. Debate. The lady from 19.
Thank you, Mr. Speaker, to debate the bill.
Lady has the floor to debate the bill.
Thank you, Mr. Speaker. If this bill were about having accurate definitions in statute, the sources consulted could have ranged from medical and scientific texts to Webster's dictionary even, none of those sources would have led to the language that we see in this bill. The sources consulted for this bill are ideological. They're the Heritage Foundation and the Alliance for Defending Freedom, which has claimed that there's a homosexual agenda, quote unquote, that is destroying Christianity in society. So these are not the neutral sources that ought to be consulted for definitions that we want to put into our statute. And the fact is that this legislation attempts to write a segment of our population out of existence. I'm deeply concerned about where this could lead us, and I've provided a handout about what's happening in Florida, where people who are transgender are being threatened and fear being charged with fraud for trying to have an accurate agenda that fits their life on their driver's license. Transgender Idahoans, intersex Idahoans, non-gender conforming Idahoans are simply trying to live their lives. They want to be able to go to school, go to work, spend time with their loved ones, and just leave a peaceful existence without facing discrimination or others telling them they are wrong for being who they are. They want to have the freedom to carry a driver's license so that they can drive somewhere in their car, prove their identity to open a bank account, or take a flight. These aren't special privileges. These are things that any of us could easily take for granted. And so I just want all of our transgender and nonconforming fellow Idahoans, and especially our kids, to know that they are perfect and lovely just as they are, and we should never send a message indicating otherwise. And that's why we need to vote no on this bill.
Lady 17.
Thank you, Mr. Speaker, for debate.
Lady has the floor to debate the bill.
Thank you. So during the last legislative session, you all have heard House Bill 71, which defines sex being the immutable biological and physiological characteristics, specifically the chromosomes and internal and external reproductive anatomy, genetically determined at conception and generally recognizable at birth, that define an individual as female or male. This bill seems to state that there was some confusion around that, but it looks as if the legislative record doesn't show any evidence of confusion. Last year, on February 14th, you all debated the current definition, and no one stood up to say that this definition was confusing. And less than 11 months ago, in March, you all debated the existing definition of sex again, and again there was no confusion. So I'm not convinced that the definition of sex that was adopted less than a year ago is now confusing, or that it needs to be changed anytime soon. Further issue with the bill is that it defines the word by using the same word, so it needs a better definition than saying sex is an individual's biological sex, if there is no further definition of biological sex. The adoption of the proposed definition of sex would cause countless known and unknown consequences. And we can look at one example in IDAPA. The section of rules that covers foster parents shows that it says specifications of the children's preferred family that include gender, race, ethnic background. If we pass this bill, we're inviting further scrutiny of social constructs. It really opens up a Pandora's box. If we define gender here, how long until we try to define race? If you want to vote on a bill that defines race, so be it, but I don't have any interest in telling someone what race they are. Idahoans don't need the government to tell them what gender they are or what race they are. Passing this bill would be very dangerous, and we need to protect Idahoans from unnecessary government overreach.
Thank you, good lady. I would caution the members to remember our rule dealing with reading our testimony. Heads up. Further debate. Good gentleman, 17.
Thank you, Mr. Speaker. You know, as I listened to the testimony in our committee on this bill, I learned a lot, because this really was an area that I didn't know a lot about. And we had 16 people give us their stories on and their personal history, very, very personal history. And there are people who are born who don't exactly have a gender identity. It's on the internet it says maybe 1 in 200. At the committee, I think somebody said it was as much as 2 in 100. And what happens is, just like every other part of our body, there's a situation where maybe there's both characteristics, male and female, that a person is born with. And so as I started thinking through that, because I really had never thought about that, I thought, well, okay, so here we're going to make a law that you got to decide when you're born, or the parents have to decide, or somebody has to decide one way or the other, you're this or you're that. And it's a government law. I mean, it's not a personal decision by the people involved exactly, because there's going to be these legal guidelines. And I became really, really uncomfortable with this bill, because I don't think that's the government's job exactly when you have a child. I mean, you know, having a child is such a big deal anyway. I had 2 of them, and my wife had 5. And to confront a situation where, well, we've got this condition, and what are we going to do, and how do you want to handle this? And I just am very uncomfortable making a law, a hard, fast law, saying, okay, well, you're this, you're that, you're this, you're that, especially when the wording indicates could or would progress to being this particular gender. Well, maybe it doesn't. Maybe that doesn't happen. I mean, I don't think that growth is that predictable. So I got a huge, I really became concerned that this bill is not an appropriate tool for government and is not an appropriate law for us to enact.
Thank you, good gentlemen. Is further debate on the motion? Hearing none. Good lady from 18.
Thank you, Mr. Speaker. Would the good sponsor yield to a question?
Would the good lady from 30 yield to a question?
The lady yields.
The lady yields.
Thank you, Mr. Speaker. Thank you, good lady. Just for clarification, would it be the case under this bill that if a person has undergone gender reassignment treatment, has done the whole deal, the hormones, the surgery, has gone to court, gotten a name change, gotten an official declaration that they are now that their gender of their choosing, that they would they be able to, what gender would appear on their driver's license? Would the DMV be able to issue a driver's license in their chosen gender, or would it have to be in their birth gender?
Good lady from 30.
Mr. Speaker and good lady from 18, this bill is not about driver's licenses, and that policy would have to be established in regard to driver's licenses.
Good lady from 18.
Thank you, Mr. Speaker. Thank you, good lady. Well, I guess, actually, that's it. I don't have a follow-up, but I would like to briefly debate, Mr. Speaker.
Lady has the floor to debate the bill briefly. Remember, you said briefly.
Yes, thank you. I share all the concerns that have been expressed on this, and I've heard from many members of this community who feel really genuinely hurt and stricken and bullied by their government, by this bill, and by a trend in recent years. But, you know, this bill, it doesn't fix a road. It doesn't get rid of grocery tax. It doesn't, you know, repair broken ceilings in schools. It doesn't get anybody health care. This doesn't do anything to make anybody's life any better. It only harms. Really, the only thing that this bill accomplishes is make an already vulnerable, beleaguered minority feel further persecuted and feel that their government just wants to legislate them out of existence. You know, it's simply not true that there are only 2 genders. There are people who were born with female genitalia who have XY chromosomes. There are, I think, 1.7% of the population who are intersex. There are transgender people who are that gender recognized by law. And I guess I would also take issue with the fiscal note. We've already lost this case. This case has already been ruled on unequivocally when there was a bill already to say that people can't change their birth certificates. And that they have to stick with the gender they were born with. We've already lost that in federal court. We're definitely going to lose this again if this goes up. So this will cost us money, and we will lose. This is really just an unfortunate gesture that makes people in this community feel unwanted and unloved by their government. I don't think that's what we should be here for. We should be here to be inclusive, to represent all of the people. These are good, hardworking people who are paying taxes. They don't deserve to have their government come out and say they don't exist and that they're not recognized. So I hope you'll give this your red light.
Thank you, ladies. Is there further debate on the motion? Hearing none. Gentleman from 1.
I've received quite a few emails from home on this, but my primary interest is when I did the little research, reading the bill, there's part of the bill is, I say it's rests on a bill that we ran last year. That bill is still in the court system. For me, I think it would be conservative to let that bill run its course, let that court case run its course, and then we could decide on what a next step would be. I'm uncomfortable. I feel like this is building on a foundation that's a little bit sandy, if you will, and I think we should wait and let the courts play out and then make our decision. Thank you.
Thank you, gentlemen. Is there further debate on the motion? Hearing none. With the good lady from 6.
Thank you, Mr. Speaker. Would the good lady yield to a question?
The lady 30 yield.
The lady yields.
Lady yields.
Thank you, good lady. In light of the good gentleman from 1, have you had an opinion or anything? I haven't seen anything come through, but have you talked with anyone about the possibility of a discrimination lawsuit being lodged against the state of Idaho if we adopt this?
Good lady 30.
Thank you. Mr. Speaker and good lady, there's always a possibility that someone will bring a lawsuit for any piece of legislation.
Thank you, lady. Good lady from 6.
Follow up.
Would you, good lady from 30 yield?
The lady yields.
Lady yields.
So really, but my question was, have you received any kind of documentation or an opinion from the Attorney General's office or other attorneys based on the legislation?
Good lady from 30.
Mr. Speaker and good lady, I have had excellent legal counsel on this legislation. I have every reason to believe that it is drafted in the best way possible and should hold up.
Thank you. Good
Thank you, lady. Further debate on the motion? Gentleman 28.
Good Speaker, members of the body. I think the gentleman from 1 has a great point made. If we're trying to spend money here wisely, we should probably wait until we have a ruling from the court. It also bothers me that anytime we put people in different silos, you open the doors for persecution and other things. So I will be voting no on this.
Thank you, gentlemen. Is there further debate on the motion? Gentleman 10.
I did not want to rise to speak, Mr. Speaker, but I am to debate in favor of the bill.
Thank you, good gentleman.
With apologies. There's a reference to a court case pending. Permission to talk about that court case legislation. House Bill 71.
Is there an objection? Are you going to read from it or talk about it?
Just talk about it.
The gentleman has the floor to debate.
All right. Thank you, Mr. Speaker. House Bill 71 passed into law, signed by the governor with some enthusiasm. That is before the courts now. I have every confidence that as that rises through the courts, that's going to prevail. And that's what we do. Sometimes we hire lawyers and we fight these cases for our bills that we all pass into law. And that does happen. I don't see that happening so much with this bill. It's pretty plain. I have also spoken with attorneys on this bill to make sure it's straight and good. And I'm hearing unicorn arguments on the floor today of things that just don't apply to this bill. They're what ifs, they're unicorn arguments. Those aren't going to happen because of this bill. This is just a clarification of language. We need that. Anecdotally, I had a police officer stop and say, Bruce, I don't know what to do. I pulled over this person, I think it was a woman, he said, they wanted to be called they, them. How do I write this report? And she was insisting that I call her they, them. It was a group of people involved in this accident. I can't do that. I have to say he, she, man, woman, mother, father. So that was a discussion I had with a police officer. That's anecdotal. By the way, I take umbrage that anybody would say because of this bill, I don't support the constitutional rights and the Bill of Rights for every human being in Idaho. Every human being, regardless of where they're at or what they're doing, how they describe their family or themselves, has the rights protected by our Constitution and this body, including me. Let's see. And these are just common sense definitions. We had discussions in committee about this, and the people who testified. Definitions follow science. XX, XY, we discussed that last year. It's in every cell of our body, whether we're male or female. Faith, we discussed faith in our committee, not because the committee brought it up, but because those testifying. Both the Quran, and that's why I'm bringing it up, and the Bible and the Torah, man, woman. And then there's just societal tradition of thousands of years. Man, woman, father, mother, child. It's just history. It's not that complicated, but we're going to run into problems in our legislation if this keeps on where we can't even define man or woman or boy or girl. So this is, for me, clarification. If we want to have other bills run, then we start from that basis and run what you like on these other unicorn issues one way or the other. So I hope you will give this your green light today. Thank you.
Debate on the motion. Hearing one, would the good lady from 30 care to close?
Thank you, Mr. Speaker, and good ladies and gentlemen. In my opening, I stated that we're here to answer a question about whether we believe that it is appropriate to define sex-based language in our state statute and whether that's beneficial. As you have heard today, there are some who believe that we should not, and that a simply written, straightforward, biology-based definition of male and female is inherently harmful and discriminatory. I have more faith in our state than that. I believe that we can have clear communication about biological realities and still be respectful and considerate and still equally protect the constitutional rights of all people. And that is the foundation that this bill seeks to lay. I'm going to address briefly the comments about intersex individuals simply because I happen to have the research here on my desk. There are some statements circulating that as much as 1.7% of the population has these disorders of sexual development. I printed off an abstract from PubMed, and I won't read from it, but it's from the National Institute of Health, the National Library of Medicine, a very reliable source, and it tells us that when you take out of this statistic things that really are not technically intersex, the true number is 0.018%. Now, I don't share that number with you to say in any way that the situation of these individuals should be disregarded. As I said in my opening, we should take those things into consideration when we write legislation, as we did in the birth certificate legislation and as we did in the House Bill 71 that was referenced earlier. But we still need to be able to have an intelligent conversation based on language that everyone understands. And I think, last of all, in reference to the birth certificate language, which was discussed earlier, and there was an allusion to this being declared null and void, unconstitutional in the courts, I would just like to clarify that this issue as well is still an open issue. It has not truly indeed been found to be unconstitutional. This is an ongoing question that is pertinent to every Idahoan, to teachers, to policemen, to us as policymakers. These questions of male and female and when it is and is not appropriate to have differential treatment and protections in the law is a salient question of our time, and I think it's time to provide some clear definitions so we can have that conversation. Thank you so much.
Thank you, good lady. The question is, should House Bill 421 pass the House? Clerk will unlock the machine, and the members will cast their votes. Has every member voted? Manwaring, Gannon. Does any member wish to change their vote? Clerk will lock the machine and record the roll. 54 ayes, 14 nays, 2 absent and excused, majority having voted in favor of House Bill 421. House Bill 421 is passed the House. Is there correction to title?
No correction to title.
Hearing no correction, the title is approved. The bill will be transmitted to the Senate. The House will now have before it House Bill 393. Good lady from 24.
Thank you, Mr. Speaker. I ask unanimous consent to dispense with further reading of House Bill 393.
Unanimous consent has been requested. Is there objection? Hearing none, good lady has the floor to present the bill.
Thank you. Today I am presenting House Bill 393, which would add Idaho to the list of counseling compact states. Currently, there are 32 states who have joined the counseling compact and 10 states that have pending legislation. Idaho currently participates in 5 other licensure compacts, 2 of which were passed from this body in 2022. The Counseling Compact is an interstate licensure compact that is designed to foster licensure portability, increase access to services, and enhance public protection for the counseling profession and its clients. The compact is built on uniform standards of care that exist among states. So if Idaho did not already have those same standards of care that other states share, they would not be eligible to participate in the compact. The compact facilitates interstate licensure by allowing someone from a participating compact state who holds a valid, unencumbered license in their home state or their state of primary residence to gain a privilege to practice in another state. So they have their license in their home state, and then if they choose to, they can get a license in another compact state so that they have what's called a privilege to practice there. Licensing does remain the sole purview of the states. So they have total authority to determine the criteria for granting a license to anyone within their state, even if they are doing this through the compact. A counselor applying for a compact license in their home state is required to abide by the rules and laws within that state. Likewise, if they apply for a privilege to practice, they have to abide by the laws and rules for the state in which they ask for the privilege to practice. So a counselor in Idaho practicing in Idaho is subject to Idaho laws and rules. They are not subject to laws and rules of another state while practicing in Idaho, even if they are part of the compact. It is important to note that state-specific licensure remains intact, the state's scope of practice remains intact, and the state's ability to collect fees remains intact. Joining a compact does not give up state sovereignty. It is merely an agreement between states that has been found to be constitutionally sound. There are uniform standards set forth in a compact, which includes things such as they must be a licensed clinical professional counselor. States must require the nationally recognized exam, which we do. So this does not apply to other areas, only licensed clinical professional counselors, not social workers, not psychologists. Psychologists actually have their own compact that Idaho participates in. Last year, we passed a bill allowing counselors to register in Idaho from outside of Idaho to practice here. And it did not allow for the portability of licensure from Idaho counselors to practice in other states. So this builds upon that, and it expands the ability for people not only to come into Idaho, but for Idaho counselors to practice in other states via telehealth. The advantage of the compact the advantages are numerous. The improved access to counseling services for Idahoans is significant. If someone in Idaho who is receiving counseling services goes on an extended vacation, if they happen to be in a compact state on vacation, their counselor could continue to see them by receiving a privilege to practice in that state. Right now, it is not legal for a counselor to treat their patient when they are outside the state of Idaho. If a client moves from Idaho, the same would apply. Counselors can help clients in crisis, even if they are not currently in the state of Idaho, if they have the privilege to practice in that state. And the privilege to practice can be received very quickly through a compact. A counselor that moves to Idaho from another compact state can transfer their home state license to Idaho. If someone is receiving treatment, the client can continue with that same counselor even if one or the other of them relocates. I have received some questions about the commission and how that works. The commission is there, just like other compact commissions, to implement and administer the compact. The rulemaking authority of the commission is only with regards to administering the compact. They cannot pass policy. That is limited to the states. They do have rulemaking authority, but it is only to dictate not to dictate policy to member states. The compact language is specific in stating that member states retain control over the practicing of counseling within their state borders. The commission is simply a tool to facilitate interstate licensure and to coordinate that. They must act within the compact of which each member state has a representative. The oversight comes from the states and their representatives on the commission. Each member state has one representative on the commission. State legislatures also maintain oversight. And if we decided at some point that the compact was no longer good for Idaho, we as a legislature could vote to repeal the compact, and we would no longer be participating. The rules promulgated by the commission go through much of the same process as our rules here. Before approval, the rules are posted on the website of the commission as well as that of each member state. There's a public comment period. There are open meetings. And after the rules are adopted, if the majority of state legislatures of the member states reject the rules, then the rule would have no further effect in any of the member states. The fees charged by the compact are paid by the state board. So somebody asked me about the fiscal note. There is no impact to our fiscal. There is no fiscal note because the state board is paying those fees. Those fees come from people who are applying to participate in the compact. This counseling compact is good for Idaho. It provides client safety as the compact states share their disciplinary actions with one another, but yet each state still maintains their own decisions on actions taken against a licensee in their state. There is a rapid verification of licensure status, and there is a continuity of care for clients providing better and safer access. This can also help our rural communities with increased access. Our military spouses and those who are on active duty who are counselors can more easily practice around the country as they move for their military assignments. Our Idaho Counseling Association has asked to become part of the Counseling Compact, and I would remind the body that there is no requirement for a counselor in Idaho to participate in the compact. When we join the compact, someone could still opt to have a single state license within Idaho. This just gives the option for counselors to participate in the compact and have privileges in other member states. I would ask for your green light, and I would be happy to stand for questions.
Thank you, ladies. Further debate on the motion. Gentleman from 19.
Thank you, Mr. Speaker. To debate the bill.
Gentleman has the floor to debate the bill.
I actually am still in the process of trying to weigh all of the pros and cons and the evidence, and I actually just wanted to comment on a piece of literature we were all given by the good gentleman from 6.
Good gentleman, make comment.
Yeah, so just a request for the body. I always appreciate it when you take the time to distribute information. I consider it very helpful. I try to consume it all. I don't think the good gentleman authored this piece, but it was sent to us. I would just ask that we do not put too much weight into its contents. I have found in my pretty close review that it is littered with false statements of fact and misrepresentations of fact. I'm not going to go through them all. I will just point out one example. The fifth bullet says page 16, line 9, and then bolded in that section says, "We have determined that rules do not have the force of law." That is patently false.
Point of order.
Good lady.
Thank you, Mr. Speaker. I'm not sure I have the document you're referring to on my desk.
Good gentleman, I don't have it up here either.
Okay, well, then may I just speak more broadly then?
And to continue to speak more broadly
Thank you.
on your debate.
If the following point is something that you are considering, I would ask that you do not. Some people are arguing, I think, that administrative rule does not have the effect of law. We have decided as a body that that is not true. We have adopted Idaho Code 67-5201 sub 24 sub A, which reads, and I quote, "Rule means all or a part of an agency statement that prescribes law. Rule is law." Please take that into consideration.
Good gentleman, was that debate for the bill then, I take?
I guess I'll find out.
Well, the speaker will rule that you voted, that you debated in favor of the rule, in favor of the bill. Is there further debate on the motion? Good gentleman, 13.
Mr. Chairman, I guess I would declare Rule 80. My son is a family counselor, so as usual, I speak from in practice. I had him take a look at it, and he was supportive of it. He is son 1.0, section 0, number one son. And that being said, again, in practice,
so the good gentleman is declaring Rule 80. Would you like to debate the bill?
I would like to debate.
And by the way,
in favor
not
of the
everybody
bill.
in here has to declare Rule 80, although a lot of us probably ought to see a counselor. Continue, good gentleman.
Right. And I don't have anything here you haven't seen. So that being said, in practice, he was supportive of it. And again, the end result being that he would be able to help his clients better. Anything that he felt that would improve that is an improvement and is something that is worth pursuing. You know, he's got clients that travel, vacation, whatever the case may be, work, many different states. And like I said, just the point was, without getting into the weeds of anything, that in practice felt positive and was something that would help him benefit his clients. And I think that would, if we were to pass this, would benefit those that are using these services. So
thank you, gentlemen. Further debate on the motion? Hear none. Good lady from 2.
Thank you, Mr. Speaker. Would the good lady yield to a question?
Good lady from 2. Just a second. Sorry. Just a second, good ladies. Good. I called on the good lady from 2. We'll come back to 30 in just a minute. Go ahead, good lady from 2. You have the floor.
A lot of good ladies in here.
Yeah, there's a lot of good ladies, and on both sides. With the good lady, are you asking a question, or would you like to debate the bill?
I would like to ask a question to the
The good
sponsor.
lady from 24, stand for question.
The lady yields.
She's standing. She's ready to go. Good lady from 2.
Thank you, Mr. Speaker. Good lady. On page 14, it talks about this database, and I just wonder if you can, it talks about coordinating it and some of the information. Can you give me more detail on what this database would look like?
Good lady from 24.
Thank you, Mr. Speaker. So there already is a national database where there is stuff is sent if someone has an action taken against them as a counselor, but this coordinates that a little more so that states can more readily see it, and it's a little faster, but there is already a database.
Good lady from 2.
Okay, thank you.
Hey, good lady. Good lady from 30. What purse do you rise?
Thank you, Mr. Speaker. I'll pay closer attention to my numbers from now on. I'm wondering if the good lady would answer
Lady
a question.
24 yield a question?
The lady yields.
Lady yield.
Thank you, Mr. Speaker. I'm curious to know how ethics rules apply in this situation. I see in the bill that there is a goal of uniformity of licensure requirements. You talked about how discipline or counselors would be subject to their own state laws, and yet if they're operating under a compact, I'm wondering where ethics rules fit in to all of this.
Good lady, 24.
Thank you, Mr. Speaker. Good lady. So with the compact, if you are practicing in a state, so if you have an Idaho license and you're practicing in Idaho, you're subject to the laws and rules in Idaho. So an ethics complaint would have to come from someone in Idaho, and it would be subject to our rules. If you're practicing in a different compact state, then you have to abide by their laws and rules.
Good lady from 30.
Thank you, Mr. Speaker. Would the lady yield to a follow-up question?
Good lady yield again.
The lady yields.
Lady yields.
Thank you, Mr. Speaker. I'm curious to know, good lady, if a counselor is practicing under this interstate compact and an ethics complaint is filed against them by someone in another state, if there is a chance that that ethics complaint could affect the standing of their Idaho license.
Lady 24.
Thank you, Mr. Speaker. Good lady. So the state that is where the ethics complaint has been filed they get to rule on their ethics complaint. That would be reported to the state of Idaho, but we are under no obligation unless it also conflicted with ours, and we chose to do that. But we are under no obligation, and the person would not be subject to those problems in another state here.
Thank you, lady 24. Good lady 30.
Thank you, Mr. Speaker. To debate the bill.
The lady has the floor to debate the bill.
As many of you will remember, I've worked very hard for greater access to mental health care for people in the state of Idaho. This is an issue that's very important to me, and I know you're probably a little tired of me today. I debated internally as to whether I would stand up. But I also have had the opportunity to work very diligently to ensure that Idaho counselors would have conscience protections under Idaho law and under the ethical standards that they practice under. You may remember a bill which passed from this body over to the other side, providing those counselor conscience protections last year. And that bill died, unfortunately, in a tie and is not the law of the land. We do not yet have conscience protections. I have concerns about this legislation, in part, and the document which was referenced earlier was in people's mailboxes off of the floor. So that is why many of you may not have it, but I happened to notice it and bring it with me to the floor today. This is a document that was put together by professionals who are currently practicing in the state of Idaho. They may not be attorneys. They may not have everything on this document 100% right. But I can tell you that as I review the list of concerns, there are things that concern me also. Among those would be the language on page, let me find it, 16 of the bill, lines 9 and 10. The provisions of this compact and the rules promulgated hereunder will have standing as statutory law. These are rules that are promulgated by a quasi-governmental body that we have no oversight over. And so in light of the conflicts that we already have over things like conscience protections for counselors, where we have an Idaho Counseling Association who, and Mr. Speaker, may I ask permission to read from the 2023 legislative session wrap-up from the Idaho Counseling Association?
It has been requested to read. Is there an objection? Hearing none, the good lady may read.
Thank you, Mr. Speaker. This is an organization who came to committee and testified against counselor conscience protections, stating that counselors were required to check their values at the door when they entered the profession. In their legislative wrap-up, they said, in part, the most significant effort this session was our fight against House Bill 63. This bill, if passed, would have contradicted the American Counseling Association's Code of Ethics by allowing counselors to refer a client to another provider if they had a values conflict treating the client. We afford this respect in the area of abortion. We have conscience protections for those individuals. We don't require them even to refer. In fact, we protect them from having to refer because we believe that if they have a moral objection to that activity, they shouldn't have to participate in it by providing a referral. Last year's bill was generous in offering that, and yet the Counseling Association found that one of their greatest successes was to kill this bill, protecting Idaho counselors. In addition, I took hours of my time to work with the Counseling Association on language around our school counselors, and was dismayed to find, after my good faith effort to involve them in the conversation, that their legislative wrap-up reported our other goal of blocking any adverse school counseling legislation was also successful. There are other associations in the state of Idaho. This one association does not represent everyone. But the fact that they are supportive of this compact is not especially persuasive to me when my primary concerns with the compact are the possibility that, first of all, we are further constrained in our ability to provide conscience protections for Idaho counselors, and second of all, that a counselor practicing under this compact is going to be practicing subject to the ethics laws in those other states, and with no protection in Idaho law against an individual who may be offended and seek to coerce someone into providing services that violate their conscience. An ethics complaint filed even in another state could have an effect on the standing of their license. This is a significant piece of legislation. I support expanded access to mental health care, but there's a lot in here that we have not yet digested. I appreciate the concern that maybe an Idaho resident who is working with a counselor may benefit from the ability to maintain that counseling relationship when they travel to another state. There are simpler ways that we could address this concern in statute, simply by stating that the location for the service is the individual's home residence. And then if they go on vacation, then they're still covered. We could do that. We don't need this counselor compact to do that. We also don't need this counselor compact for Idaho residents to have access to services. That already exists in the legislation that we passed before. What this does is say Idaho counselors who already have very long waiting lists will have an expanded population to serve with their already limited resources. And so under those circumstances, I don't find that a compelling reason to support the legislation either. And I'm going to be a no on this today, especially until we get to a place in the state of Idaho where we have answered the question about protecting the sincerely held beliefs of professionals in the state of Idaho. So I would urge you to support me in that no vote.
Hey, good ladies, further debate on the motion. Hearing good gentleman from 33.
Thank you, Mr. Speaker. To debate the bill.
Gentleman has the floor to debate the bill.
So some of you may recall a couple years ago that I had a very similar bill to this that was for psychologists in the state of Idaho. It's my opinion we need to do this for all the professions. Of course, as the good lady from 24 pointed out, we can't. You have to do each profession separately. I'd love to see the social workers and all of our professionals be able to have a compact like this. In fact, in committee, just so you're aware, we have been looking at the rules specifically of incorporation, specifically to this set of code. And our committee has been very aware that they incorporate by reference code of ethics. And so just this morning in our committee, we had a review from the state, and we wanted to look at how is it possible for us, when they take a piece of code and they incorporate it by reference, how can we object to something like the national standard if we don't like something? They said to us, it has never been done in Idaho, and it was really clear that our committee is potentially looking at doing that. And the question specifically asked was, is there a possibility to reject a section of the Code of Ethics without having to pass a law that says that? And the answer we received was yes, but it's never been done. And so there is a close review of that process inside our committee. And know that the individual members have been raising those questions, looking deeply into those, even to the point where we've been asking for further documentation, specifically asking for those whole entire Code of Ethics to be incorporated into our ability when we're pulling up those documents to look at what those codes are. So the committee is very engaged in that right now. I just want the body to be aware of that, and that I fully support this work moving forward.
Thank you, gentlemen. Further debate on the motion. Good lady from 6.
Thank you, Mr. Speaker. I am rising to debate for the bill.
Lady has the floor to debate in favor of the bill.
Thank you. I sit as a ad hoc member to Region 2's Behavioral Health Board. And in our region, and I'm sure in many of your areas, is the same thing, is that there is such a low number of counselors compared to the people that need help. When folks are saying, I need help, and they said, okay, we can get you in 6 months, that is not acceptable. And so I am really happy that the lady from 24 is bringing this. I think that it is going to help the situation, particularly in areas like mine. We are on a border, and if the Washington folks would be able to help our Idaho folks, both up in Pullman to Idaho to Moscow, and from Clarkston to Lewiston. And so I would urge you to consider that this is a positive and not a negative. And so thank you, good lady, and I encourage your green light.
Hey, good ladies. Further debate on the motion. Good lady from 2.
Thank you, Mr. Speaker. I just want to share, every time we delegate some of our authority to someone else, we're just opening ourselves up for more damage to our citizens. We are supposed to represent our citizens. It's hard enough to move government in a direction at the state level. Now we're going to turn this over to an unelected board, like a bureaucracy, and it's outside of our state. They're going to be promulgating rules that are going to have the full force of law, and we have no say in it. We're here for 3 months. I see this as another way to give away more of our power to represent our citizens. Every time we pass the buck for someone else to make the hard decisions, create the rules, set the standards, keep the databases, whatever that may be, every time we delegate that authority, we lose more and more control over how we can help our citizens. I'm urging you to not throw away your power as a legislator to an unelected board outside of the state, and to stand up for your citizens and vote no on this.
Hey, good ladies. Further debate on the motion. Hearing none. Would the good lady from 30, what purpose do you rise?
Thank you, Mr. Speaker, to debate for the second time.
Is there anybody who wishes to debate for the first time? Hearing none, the good lady has the floor to debate for the second time.
Thank you, Mr. Speaker. I'll be very brief. Just in light of some of the comments, I just wanted to be clear. This is not about allowing access to more counselors for Idaho residents. This is about allowing Idaho counselors to provide services outside of the state of Idaho. We already have the ability for counselors in other states through an expedited process to practice into the state of Idaho.
Hey, good ladies. Further debate for the second time. Hearing none, would the good lady 24 care to close?
Thank you, Mr. Speaker. So compacts provide a pathway for counselors to easily move from one state to another through an agreement between those states that recognize another state's license. It also allows for interstate practice through telehealth, and both of these things will help Idaho citizens because, as I mentioned before, when they are traveling or if they move, they can maintain their care with their current counselor. The rules by the Commission are only to administer the compact. The state rules regarding licensure and scope of practice remain, and I think that's important to remember. State laws also supersede ethics, and Idaho licensees must abide by Idaho laws. Counselors with dual licensed right now, without the compact, if somebody is dual licensed, they still have to abide by the laws and rules of whatever state they are practicing in. So, for example, my husband is a physician. He's currently licensed in 9 states. He works for 9 different states. When he's reading radiology studies in Tennessee, he has to abide by the laws and rules for Tennessee. What he does in Idaho has to be due to the laws and rules in Idaho, not Tennessee. And so this is it's the same way, the same program. I think that this will give counseling services, it will expand that opportunity for Idahoans, and it still keeps patient safety at the top of mind. So remember that Idaho counselors have the option to participate in this. When we become a compact state, an Idaho counselor can still choose to be a single state licensure. And if they decide to participate, then they have the opportunity to apply for a privilege to practice in another state. I would also mention that that letter that was put in our mailboxes or on your desk on Monday, only 2 of those signers are actually affected by this as LCPCs. This only applies to licensed clinical professional counselors. Psychologists already have a compact. Social workers do not fit into this. School counselors as a school counselor do not fit into this. So it's only LCPCs. And again, I think it's good for the people of Idaho, not only our counselors, but also for their clients and those who are receiving treatment. And I would encourage your green light.
Thank you, lady. Debate is closed. The question is, shall House Bill 393 pass the House? Clerk will unlock the machine, and the members will cast their votes. Has every member voted? Raise furnace. Does any member wish to change their vote? Clerk will lock the machine and record the roll. 38 ayes, 31 nays, 1 absent and excused. The majority having voted in favor of House Bill 393. House Bill 393 is passed to House. Is there correction to title?
No correction to title.
Hearing no correction to title, the bill is approved and be transmitted to the Senate. The House will now have before it House Bill 457. Good lady from 32.
Thank you, Mr. Speaker. I ask unanimous consent to dispense with further reading of House Bill 457.
Unanimous consent has been requested. Do I hear an objection? Hearing none, the good lady has the floor to present the bill.
Thank you, Mr. Speaker. May I also have unanimous consent to refer to pending legislation?
Unanimous consent has been requested to refer to pending legislation. Is there objection? Hearing none, the good lady may do so.
Thank you, Mr. Speaker. If you do not have a handout that was sitting outside ready for these debates yesterday, please let a page know there are additional copies out there. And just let a page know, and they will get the handout to you. This is the budget for the judicial branch. It includes the Supreme Court, the Court of Appeals, district courts, magistrate courts, problem-solving courts, like drug addiction courts, and also covers the guardian ad litem program, which are court-appointed advocates for abused, neglected, and abandoned children who advocate for them in the court system. It also includes the maintenance budget for the Judicial Council, who nominates judges. If you turn, well, let me say one other thing here. This is the first of 10 maintenance bills that have been approved in JFAC. We've organized them by functional area in the legislative budget book. So K-12 education, higher education through the state board, health and human services, public safety, courts, which is this one. We wanted the three branches of government to be considered separately. So courts and the legislature will have their own maintenance budgets. And then, where did I leave off? Economic development, general government, and constitutional officers. So those are the 10 bills that have come from the Joint Finance Appropriation Committee to the floors. A reminder that the purpose of doing the budgets this way, which is new this year, I understand we've had a lot of questions and have been happy to answer those, is to increase transparency and accountability for growth in spending and growth in government. Turning to the statement of purpose, you will see it starts at the top with the FY24 original appropriation. One of the flaws in our current budget process is that during the legislative session, the Joint Finance Appropriation Committee reviews only approximately 19% of the spending of agencies. Another step in the process, though, is that the spring and fall meetings are going to be taking that number that you see there at the top, the FY24 original appropriation of $90 million, and really digging into the base. The plan is that we will assess 20% of each agency over the course of 5 years, so that during a 5-year period, we will actually get a complete look at everything under the hood, not just the new spending. In the meantime, we have added to our budget website, which you can access from the legislature's website where it says budget information, a link to Transparent Idaho. So if you have a question about what's in that $90 million, which I'll remind you again what the good Chief Justice said represents 1% of the state's general fund spending, only 1% for the third branch of government, you can go to that link and you can dig as deeply as you would like. You can see it at summary levels, you can see it at transaction levels in terms of individual financial transactions. You'll see a prior year reappropriation there. During the pandemic, the courts had to shift quickly and dramatically to the safety provisions that were in place at the time, implemented by the courts, and so that meant a lot more cases were filed online, digital evidence sharing, remote hearings, and virtual operations for management of court administration. So those are funds that will be reappropriated for that use. Carryover is some contractual obligations where if they've obligated it through a contract, we grant them the funds to move that forward. Removal of one time, which is standard. You can't leave one-time funds in your home budget for ongoing use either, which gets us to the base. From the base, then, we add insurance costs for their employees, statewide cost allocation, which is the cost of state agencies paying one another for services. So the Attorney General, IT services, risk management, the State Controller's Office. Those are fees that agencies pay to each other. Sometimes that number goes up, sometimes it goes down, depending on your usage. Next is the change in employee compensation. That is the standard 1% placeholder as requested by the agencies in September. Should this body choose to accept the recommendation that has come from JFAC for additional 2%, that would be another approximately $450,000 coming in the future bill with the line items. And because this is the first of these bills Mr. Speaker, I would just like to address the line items that will, when we have the budget hearing, receive consideration. It's $9 million for more court technology support, and looks like I got here. Anyway, there's another one for $700 and approximately $80,000 for statewide administrative support. You'll notice this looks like it's a 2% cut because that's measuring the change from the FY24 original appropriation at the top. But if you take the FY25 base and include personnel benefit costs, statewide cost allocation, change in employee compensation, and add that to the program maintenance, you can see there's a difference of $372,200. It's actually a 0.4 increase. When the future budget comes, you will be able to see all of it on one page and see what the growth is and where that growth is coming from. With that, Mr. Speaker, I'm happy to answer any questions and would ask for your green light on this budget bill for the courts. Thank you.
Good lady. The good gentleman would take a privilege for a minute and recognize the good lady from 23 because the speaker had him. The speaker made a little mistake a minute ago and would recognize the good lady from 23 to make an introduction.
Thank you, Mr. Speaker, for this point of privilege. As the body may notice, our gallery filled up very quickly. And so if everyone, would you please welcome our friends from the Farm Bureau from all across the state.
Welcome, everybody. Thank you for being here. We'll continue debate. Good lady from 34.
To debate the bill, Mr.
Good
Speaker.
lady has the floor to debate the bill.
It's been an interesting few weeks in this body, and there's been a lot of discussion about what the budgeting process should look like in this state. I think the majority of this body has agreed that there is a need to have greater transparency and understanding about what the budgeting process looks like. Where the gap remains is in how we define what it means to maintain operations and services for our state agencies. Now, I like to think about this a little bit like, a family budget. And every family is a little bit different. And what's required to maintain in one family may not necessarily be what's required in another family. And yet what we're debating today is a process that creates a cookie-cutter approach to budgeting that doesn't take into account the differences that exist amongst the different state agencies, driven in large part by the laws passed within this body. Our state agencies exist because of the responsibilities and duties that we have assigned to them when they were created. And so take, for example, this current budget that's before you as it relates to the court system. The budget that is presented to you does not contain items related for replacement. Now, in most of the agencies that we work with, there are policies that are in place that establish how items get replaced, be it vehicles, technology devices, whatever it is that an agency may have in its inventory. There's a policy in place and they're on a schedule, just like many of our business operations in our own communities. As a business owner, I have a pretty good idea in a coming year of what I'm going to have to budget and account for replacement items because I know my inventory. I know when the time comes that I'm going to need to make that decision to have those replacements happen because that's part of my ongoing maintenance. That's part of the decision that I've made as part of my budgeting process in order to maintain the services that are required. I think the frustration we've had is getting to the point of where we agree about what it means to maintain services and operations. I am in complete agreement with the members of this body who say we don't want outstanding growth in our state agencies without question. I wholeheartedly agree with you. And I believe there is a meeting of the minds on that particular subject. If we're talking about a new program or if we're talking about a new service, yes, the question should be asked, and in some instances, I believe that question should be redirected back to the relevant policy committees and debated by the policy committees whether or not they are supportive of and agree with a new program or service being provided by the agency. But if as a body we have established through Idaho law there are duties and responsibilities that an agency is asked to undertake and carry out, that's the challenge that I see for us. As I'm looking at the court operations budget, just as an example, there is a request in their line item related to court IT operations that reflects a shift in where funds come from in order to cover some of their IT operations. Now, I understand that the way that this got submitted in the budget, it appears as though it's coming in and asking for something new. It's new in the sense that how the court previously funded some of these services that are in the line item came from dedicated funds. There's been a decrease in the total number of funds that are being collected by the courts, and so a decrease in the available funds for them to be able to draw on for these services. But if you were to read through the description, it would raise a really interesting discussion about whether or not what was being asked contributed to the ongoing services that have been established for the court to direct and to oversee. But that's a debate that we weren't able to have in committee as to related to the maintenance of court operations. So the budget you have before you today is representative of a portion of services when it comes to funding our court system. But I would argue it does not represent a maintenance of services in our court systems or in the other budgets that are included within this budget. Which leads to my second point. This path of collapsing multiple budgets into single budget bills is reflective of what the federal government does with its budgeting process. We decry frequently how budgeting happens in Washington, D.C., that it is not transparent, that it allows things to be slipped in under the cover of, well, everything's in the bill and it's all got to go. That is not a process I want to see adopted in the state of Idaho. For decades, we have had a one agency, one budget approach. And what that has meant is that when this body has considered budget bills historically, you were presented with the opportunity to review, often by down to the division level, within an agency, the decisions that were made by our appropriations committee. You had the opportunity to stand up and ask about individual items that appeared in those budgets, and to question and to challenge. And in the event that your questions weren't answered, you were in a position where you could stand up and you could say, I don't feel great about this because you haven't been able to answer my question about why this is appearing in the budget. This omnibus approach removes that transparency and that clarity about what's going into our budget process. I would argue that even as we attempt to manage the growth of our state budget, we have an obligation to hold on to that one agency, one budget approach. There is nothing that says that we can't accomplish that objective and still address the concerns about adding new programs and services to our budgeting process. As I indicated at the beginning of this debate, if those items appear in the budget requests that we receive from the state agencies, we should look to our policy committees for direction on whether or not they believe it is appropriate from their perspective to move forward with those as standalone appropriations, or if a policy bill should be considered in the committee, allowing the body to then determine whether or not it supports what's being proposed by the agencies. I know that there is division within this body today, and I respect the fact that individuals are coming at this issue from many different perspectives. But ultimately, I think we all share the same objective of ensuring that we have a budget process in place that allows for certainty going forward, transparency that allows us to actually identify individual items within the budgets placed before us, and the opportunity to actually ask questions about what our agencies are requesting of us in the process and to make the assessment of whether or not we are providing true maintenance for our state agencies. I encourage your red light on this budget bill, not because I disagree with a maintenance budget, but because I believe this particular bill is not reflective of an Idaho budget.
Hey, good ladies, further debate on the motion. Good gentleman from 14.
Thank you, Mr. Speaker. Debate in favor of the bill.
Gentleman has the floor. Debate in favor of the bill.
Thank you, Mr. Speaker. I'm a small business owner. I'm also the chairman of the fire district. Both actually has budgets. My office manager puts together requests for replacement items. It's no different than the fire district. When certain things come up, they put together replacement items. It is up to me as a business owner, me as a commissioner, as well as me as a member of JFAC and a member of this House to actually vote on what those items are. Not to say that we all agree on which items are going to get put in each one, but these maintenance budgets, as a term being used, realistically only puts a section of stuff into it, which is we're giving this body a greater opportunity and more transparency for the public on these additional options. Talk about replacement items. With some of the agencies, they might demand that some of these replacement items are 100% necessary. Some of them may not. It is not up to them to make that decision. It is up to JFAC and this body to make that decision as what we deem necessary. And that process is not necessarily changing. It just is giving a lot more clarity to that process. And for that, I ask that you vote for this budget with a green light. Thank you.
Thank you, gentlemen. Further debate on the motion. Gentleman 35.
Would the good lady from 32 yield to a question?
Lady 32 yield for question. Lady yields.
Thank you, Mr. Speaker. Good lady, I'm curious, help me to understand as we're approaching this budgeting from a slightly different angle this session. If we were to pass this budget that is before us now, would the court's budget then be considered to have been fully funded as far as state law and our constitutional duties require of us?
Good lady from 32.
Mr. Speaker, gentleman from 35, absolutely not. That's why we're doing another bill with their other requests, including replacement items.
Gentleman 35.
Thank you, Mr. Speaker. To debate the bill.
Gentleman has the floor to debate the bill.
I'll be brief. We have honestly been talking about this updated methodology for some months. I have felt like in my role as a legislator that Idaho's methodology for budgeting is truly the envy of the nation. And a lot of that stems from the fact that we have approached it by having so many individual budgets for the individual agencies so that we have the capacity to dig into line by line their requests, their needs, the statutory requirements. And in all the conversation, that was my great expectation, is that we would continue to see individual agencies and see a true maintenance budget. So I have some concerns that we've gone more to an omnibus approach. And so for that reason, I'm going to be a red light on this budget.
Thank you, gentlemen. Further debate on the motion. Hearing none, with the good lady. Oops, here we go. Gentleman 26.
Sorry to leave you out there, Speaker. To debate, please.
You're just lucky my right eye works better than my left eye. Go ahead.
I could yell. First, I agree with what's been said. When you start talking omnibus budgets, shoveling $1 billion out in one resolution, it smacks too much of what goes on in Washington, D.C. The second is, even in the title of the bill, maintenance. My concern, I'm a first-term legislator, but one of the issues that's been talked about by our good speaker a lot of times is in your debate, you don't reference another bill for clearly, to me, a really good reason. The next bill may or may not happen. My issue is passing something that's I don't consider maintenance. There's too much stuff left out. And if the second bill doesn't happen for whatever parliamentary reason that could be out there, we've got an agency that can't fulfill legislative intent because we didn't provide them the tools to do that. So in light of, one bill should be self-contained, if you will. This bill is not self-contained. It was clear doing the shoe leather and attending, out of out of legislative session education things with the judiciary. In the Magic Valley, it was really clear their number of candidates that they have for judge positions has gotten really thin. They're concerned about that. And clearly from the staff that support everything that they do, they think what they're trying to do, my words, what they're trying to accomplish is kind of like smoke signals. To handle the increased caseload in Idaho with all the growth, they need to come up to speed technologically. So for me, if it's not in there, it's simply not in there. The agency has some very clearly articulated needs, and if it's not in the maintenance budget, I can't really support a maintenance budget with all due respect to any sort of discussions we're having about the process. So for me, I'm a no, simply because, you know, it's not in there.
Thank you, gentlemen. Further debate on the motion. Lady from 2.
Thank you, Mr. Speaker. To testify in favor of the bill.
Good lady has the floor to debate the bill.
I'd like to speak so my citizens in my district understand what we're talking about here, because there's a lot of terms being thrown out, and I'm hearing maintenance and omnibus bills and base budgets, and I'm going to let you know what I think of what's going on. So in the past and up to this point, we've had big bloated budgets. They've been all or nothing. Every single want of an agency, every single need of an agency was all put into one budget. This is the first time since I've been here in 10 years that we're actually going to at least take that one big budget and turn it into two. And we can put it into two categories. What does the agency need, and what does the agency want? And that's going to come in two packets this time. So obviously, I would guess that everyone in this body is going to vote yes on everything the agency needs, because we want agencies, we want government to be able to function. But then when it comes to the wants, what's different about this budget, and all these terms are just trying to, in my opinion, just confuse people. But what this second budget comes through is, here's some wants. What it allows is it allows us as a body to look at these line items so we can say, okay, this agency wants 100 new vehicles. Do we think that's reasonable or not? And we can look down and say, well, maybe we think that they could do it with 90 vehicles. And so we can make those kinds of decisions with this new process. So by voting yes on this, you're going to be able to look at some of those other things and assess them as a body, and we can say, is this really something government needs, or is it something we think government needs, or do our people need this? The way we've been doing it, every single budget passes every year, and we never get to look, as was mentioned, under the hood. We never get to see all the line items. It's all or nothing. And as we know, if you don't like one little line item, you don't like the fact that we're going to provide an agency with 100 vehicles because you know they're sitting on 100 that they're not using, there's no way to take that out without voting no on the entire budget. And we want to be able to make good decisions with how the money is spent, and that's what this new process allows. Another thing I want to mention that was mentioned to me, it just kind of explains it. Every agency wants new stuff. We all like to get our new cell phones and update our clothing and all that, but maybe that's not necessary every year for every agency. And so what this new process does and what this bill allows is you to be able to, us as legislators, to look at, do they really need a new system this year? Do they, if they only have 50,000 miles on their car, do we really need to upgrade to a brand new car with 20 miles on it? Maybe not. This process will allow us to make these kinds of decisions as a body. Before this, we could not do this. We could not make these kinds of decisions. A lot of the process Because it was so hard to navigate, this is going to simplify it so we can make true decisions. And so I just don't want people to be confused. This will be more transparency for Idaho citizens. It will be more opportunities to slow down the growth of government. I don't think we'll ever stop the growth of government, but we will be able to slow it down a little bit with this new process. So I urge you to vote yes on this, and let's get back to transparency in government.
Further debate on the motion. Good gentleman from 1.
Thank you, Mr. Speaker. Just a comment.
Gentleman has the floor for a comment to debate the bill or a comment?
Debate.
Gentleman has the floor to debate the bill.
I debate in opposition to the bill. I'm a red light. I think we have a bundling problem. I think there's a lot of issues in the room. People are unhappy with how things are bundled. My point here is let's lift up the hood. Let's actually check out the engine, check out the transmission, get underneath and look at the rear end, check the tires, check the whole thing. I don't think making a few votes is really what we need to do. I actually think we should do more votes. And I'm not comfortable passing a budget that doesn't really encompass the whole operating system. I have some questions about a future bill. My question was, why wouldn't we bring that future bill forward and then bring the basic bill along as a trailer? That makes more sense to me. And the other point I'd like to make is I haven't heard anybody set a revenue number for our state yet, and we're asked to set budgets now without a revenue target or estimate, and I'm not comfortable doing that. So I'm a red light. Thank you.
Thank you, gentleman. Gentleman 31.
Thank you, Mr. Speaker. Just want to
debate the bill.
To debate against the bill.
Gentleman has the floor to debate against the bill.
Thank you, Mr. Speaker. Just a little bit on the process and some of the things that were said. When you get the next bill, the process is a lot different than you just heard. That next bill is going to have all those line items in it. You're going to vote that thing up or down. It's not going to have a whole bunch of different lines.
Gentleman 13.
Mr. Speaker, just a point of order. I think we need to debate the bill, not the process here on the floor today.
Mr. Speaker.
Good gentleman 31.
I'm debating the bill because of things that were brought up that were maybe not correct.
Try to keep it so we don't keep expanding, though, my friend. Thank you. The gentleman can continue.
The process is not that you'll be able to line item veto those next bills that come. You'll have one bill, you'll vote that up or down. You know, there's a lot of things about this process that I really like. And I appreciate and applaud the good chairman for what she's done. I like the fact that we've taken these budgets and made them all digital. You can look them up. You can go to those line items. You can see what they are. And I was all digital last year, but I had a stack of papers on my desk this high from all the stuff we received in JFAC. This year I have a few. We're still not quite there, but I appreciate that. We have shorter meetings, meaning that we meet for about an hour and a half, and we go out and we are able to meet with our colleagues in a work group and discuss those line items. For example, some of those line items on cars, for example, we looked at all the cars. They all had in fact, in the notes from the analysts, they all had over 108,000 miles on them. When is the best time to trade that car in? Those things are all discussed in the work group, not on the floor here. We scrutinize those budgets. We go through, do you really need that car? Do you need that typewriter? Do you need that typewriter? That really dated me. I apologize, Mr. Speaker. Do you need that printer? Things like that. We ask those tough questions, okay? And we work those budgets so hard. Those committee members, I got to tell you, the people that are on JFAC, some of the smartest people I've rubbed shoulders with. They do a great job, and they know budgets. Now, I kind of got told I was a freshman on JFAC, but I'm really a sophomore. But I have a degree in finance, okay? I have a degree in financial statements. I have an advanced degree in financial planning. I think I know budgets. And these budgets that we are voting on today are not necessarily the budgets that we want to run through. I have a deep concern that if we pass these budgets today, we've complied with our constitutional duty of passing budgets. And what would stop the Speaker from sine dying after we pass these budgets? And those maintenance items that are so desperately needed in replacements and ongoing items, and even line items, may not be there for the future agencies. Our state is growing at an alarming rate. Some of the requests we're getting for new employees, I'm astounded by. And we're working those requests diligently to see if they really need extra employees. Some of them have asked for 60 new people. You know, to me, that's incredible. What were they doing without those people, right? We're asking those hard questions. These maintenance budgets may not be up to par on what we need as a maintenance. You know, I worry about a lot of things in JFAC. I worry about how much cash we have, how much we'll have at the bottom line, what will happen if some of these line items don't go through, and they're not all going to go through. We've already gone through in committee, and we've X'd out a bunch of line items. We've done the hard work so that you don't have to. But on these maintenance budgets, I would hope that you would look at them strongly. I would hope you give it the red light. We need to look at these budgets on an individual basis so you can put the whole story together to see if you need line items, to see if they have what they need, to see if they need all those printers or typewriters that they might need. With that, Mr. Speaker, I offer you the red light.
Thank you, gentlemen. For debate on the motion, gentleman from 28.
Good Speaker, with the kind lady from 32, not really a question, but a clarification so if I heard right.
Good lady from 32, answer a question.
The lady yields to a question.
Lady yields.
Thank you. Did I understand right that these budgets before us today do not entail everything that we need to meet our constitutionality requirements to these agencies?
Good lady 32.
Mr. Speaker, a good gentleman from Preston.
28.
I can't see your number.
28.
Thank you. 28. Thank you. I am not going to weigh in, I am not a lawyer, on whether this budget meets constitutional muster. What I will weigh in on is this. This is everything the courts got last year, plus money for the increased cost of health insurance, their fees, and a 1% placeholder for CEC awaiting further action on an additional approximately $450 million. And because I happen to know who sets the agendas for the Joint Finance Appropriation Committee, I can assure you that hearings are scheduled and will happen for the other needs that the courts have identified that they have that are new spending or a new funding source that will be considered and coming to you in a future bill. I, Mr. Speaker, do not ask need to ask unanimous consent for that because it's not a bill yet, but I certainly expect it will be.
Thank you, gentleman 28.
Mr. Speaker, for one more question, will the lady yield?
The good lady from 32 yield for one more question.
The lady yields.
Good lady yields.
Okay, I've been getting a lot of concerns and feedback from my district that the judges in Idaho are underpaid compared to, and so I guess my question is, I'm wondering if JFAC looks at that when they look at the budgets. Do they look at other states or the private sectors to see how that compares?
Good lady 32.
Thank you, Mr. Speaker. A good gentleman from 28. Judicial salaries are set in the Germain Policy Committee, Judiciary and Rules. That is always a bill that is considered down in that policy committee, so that is not, we will take that up as a trailer bill once they approve whatever that number is. I share your concern that our justices and judges in Idaho are underpaid.
Gentleman 28.
Thank you, good sir.
Thank you. For the debate on the motion, gentleman 30.
Thank you, Mr. Speaker. To debate the bill.
Gentleman has the floor to debate the bill.
Thank you. Good ladies and gentlemen, I will be an enthusiastic green light on this bill. I'm excited for this bill for what it represents. I'm excited for the changes that it represents in terms of how we do budgeting in this body. I note that the evidence that this is a significant change is that that it's been a difficult road to get here, and that adversity signifies to me that we're on to something here. This is a tool for transparency, and this is a tool for those of us who put importance in scrutinizing government growth, reining in the government. That's something that I take seriously. I want to give a shout out to the good lady from 32 and her efforts in this process, and I'll be excited to cast a green light vote today. Thank you.
Thank you, gentlemen. Further debate on the motion. Gentleman 7.
To debate in favor of the bill.
Gentleman has the floor to debate in favor of the bill.
First, a comment, Mr. Speaker, and no disrespect to you at all, but it's my understanding that you cannot sine die until we vote as a body in majority to sine die. And speaking for myself, I have no intention of casting that vote unless I am satisfied with each agency being properly funded. So with that being said, I like this budget.
Point of order, Mr. Speaker. Can we keep the debate to the bill and not to procedure inside this body?
Thank you, good gentleman. Continue, gentleman 7, with caution.
I like this budget. I think it's fair to the agency as well as to the taxpayer, and I really like the new system.
Thank you, good gentlemen. Further debate on the motion. Hearing that, good lady from 32.
First, would the good lady from 32 yield to a question?
Good lady from 32 yield for a question.
The lady yields.
Can you tell us, the question I have, Mr. Speaker, is when is the last time we have started setting budgets without having set the revenue number first?
Good lady 32.
Mr. Speaker, other good lady from 32. Typically, we set the revenue number later in the session. The reason we have not set that yet is because there is not consensus around a number. We actually are planning to meet later today to meet with the co-chairs of the Economic Outlook and Revenue Assessment Committee and talk to them to see if we have approached consensus on what that recommendation should be. And as soon as we get to where we have some idea that we can move a number, we're hoping to actually add that to tomorrow's agenda.
Lady 32.
Follow-up question or clarification on that. Have we ever...
Does the lady from 32 yield to a follow-up question?
The lady yields.
The lady yields. Continue, good lady.
So my question is, have we ever started setting budgets and passing budgets without first determining a revenue number?
Good lady 32.
Thank you, Mr. Speaker. Good lady from 32, I don't know.
To debate the bill, Mr. Speaker.
Thank you, good lady. Good lady from 32 can debate the bill.
Okay, since I have a lot of farmers out here in the audience, I'm going to speak to that just for a second. You know, on my farm, if I were farming for the year and I got to my last pass in my field and my tractor puked on the last pass, there would not be a question as to whether or not I had to replace that tractor to continue to farm the next year. And when we look at these budgets and we say, gee, these people have to have necessary functions, equipment to function in the next year because their systems are going to crash or fail, that is not fat, that is not fluff, that is not pork. That is part of what we got told yesterday is maintenance of current operations. On the very worksheets that we got handed out yesterday, if you come down to the green line, it would say 2025 program maintenance, and yet those items were missing from that budget. I have a concern that we are now going to be legislating by appropriation. So if we pass bills in current session and then we go to the next session, they will say, oh, those are a new line item. And then if you had the bill that barely passed, you would be refighting again to get that particular program funded because we would be legislating by appropriation. And I think that that's a big concern. I also am concerned that we're letting personality win out over good policy And good policy says that we have a constitutional responsibility.
Good lady, I would caution you on personalities and going there. That's beyond where you should be.
My apologies, Mr. Speaker. That we make sure that we are doing policy according to what we have passed as this body in prior legislative sessions, and that we give those agencies that we have given specific duties to the ability to function. When we spend only a couple of hours, we spend $12.8 billion and do over 100 budgets in 2 hours. That does not tell me that we have transparency and we have time for people to think through the process fully. For that, I will be asking for your red light as I will be opposing this bill.
Good ladies, further debate on the motion. Good gentleman, 21.
Thank you, Mr. Speaker. To debate against the bill.
Gentleman has the floor. Debate available.
Thank you, Mr. Speaker. A lot has been said on this topic in the last couple of days. I have certainly said more than my fair share, so I will not subject you all to having to listen much more to me. But I just want to talk real briefly about the one before you right now, House Bill 457. I have two problems with this particular piece of legislation. First off, even though it's a simpler one in comparison, it is an omnibus-style bill. I don't think that that's the right precedent that we want to set for our state. And the second problem that I have is the line item that was just mentioned of program maintenance. If you look above the FY25 program maintenance line, there are numbers that are missing and numbers that are lower than they should be. And so if this is a maintenance budget, Mr. Speaker, I would argue that it should include those things. For that reason, I will be a red light on this bill.
Thank you, gentlemen. It's first debate on the motion. Gentleman, 24.
Comment.
Gentleman wants to
Mr.
debate
Speaker,
the bill.
there was a question, I'd like to answer a question that was asked from the
Well,
floor.
good gentlemen, why don't we debate the bill and answer the question in the debate? Does that work?
Well, I wasn't prepared to do that.
Well, you don't have to debate the bill, but you can say that and then you can answer the question.
Let me think for a minute.
Is there further debate on the bill? Going once. Gentleman, 25.
Mr. Speaker, for a question, if the good lady from 32 would.
Good lady from 32 yields question.
The lady yields.
Lady yields.
I understand there was requests for technology for the court system in this. Did you happen to discuss with the court administrator whether these items were necessary to maintain court security?
Lady 32.
Mr. Speaker, a good gentleman from
25.
25, thank you. Yes, I have discussed that with the director. They have not had their budget hearing yet in the Joint Finance Appropriation Committee, but I have had several meetings with the executive director of the courts to make sure I fully understand their technology request.
Thank you.
Good gentleman from 30 to 25.
To debate the bill?
Gentleman has the floor to debate the bill.
I'm going to be a red light on this one. I believe that a maintenance budget should be funded enough, and we had already heard in debate from the sponsor that this is not fully funding the court systems. And if the court system cannot operate, and if a preceding trailer bills, which have been mentioned, so I think I have the right to as well, are voted down, then how does that court system operate if those bills get voted down? Because I think that is the purpose of this for some. Well, I'll back off. I'll back off that. Sorry, I didn't mean to say that. I shouldn't have said that. Let's put it that way. I would like to see a more complete maintenance bill that I know that the court could operate at least partially if that's all they get. I don't think they can operate if this is all they get. And to me, that is not maintenance. Maintenance means that you could operate, you could do your job for the citizens of Idaho, and with this bill, the court system cannot operate. If the trailer bill fails, we don't have a court system, or one that's operating efficiently anyway. Thank you.
Thank you, gentlemen. Further debate on the bill. Good lady from 9.
Thank you, Mr. Speaker. I just wanted to clear something
Lady
up.
wants to debate the bill.
I do want to
Gabe Lay
debate
has
for
floor to
the
debate the
bill. This is a good bill. Congress has not passed a budget since 1997. I worked for Congress back then. Ever since then, they have passed enormous CRs. Enormous, thousands of pages, which no one even has the ability to read in the short time that it's on their desk. This is completely different. This is transparency for the people of Idaho, so that they know exactly what we are doing. This is almost zero-based budgeting, but not quite, and I hope we get there someday. Thank you.
Thank you, good lady. Is there further debate on the motion? Gentleman from 22.
Thank you, Mr. Speaker. To debate.
Gentleman has the floor to debate the bill.
Mr. Speaker, I've heard many times in this debate so far that we talk about line items and how certain line items are not there and how they should be there. Nowhere in this budget does it say that those won't be debated another time. I kind of feel like we're complaining about one thing, but yet we're going to go ahead and do that in the next bill. When it comes out, we talk about this, but we can't talk about them separate. If they need a new car, explain to me how they need a new car. I'm big enough. I'm a grown adult. I can accept that, and I can vote for that. If they need a new tractor because their tractor broke down, that's fine. Explain it to me, and I'll be happy to vote for that. But I kind of feel like we're not intelligent enough. That's what I hear. My message is that you're not intelligent enough to be able to vote for it if I break it up in a different format. I may not be the smartest person in here, but if you explain to me why we need something, I'll be happy to vote for it. There's nothing wrong with this budget. This is a good start. Nobody ever said it was the only thing that anybody was ever going to get. We'll have a chance to continue to look at those items, continue to look at those things, and if we feel that it's necessary, then we'll vote for them. But this is just a start. Thank you.
Thank you, gentlemen. Is further debate on the motion? Gentleman from 25.
Thank you, Mr. Speaker. I want to explain why I'm going to vote in favor of this bill.
Gentleman has the floor to debate the bill.
I know this is a major change, and it's hard to talk about this bill and the issues without mentioning the process, but I would probably feel much better if I knew that the next bill we were voting on had all of the line items to be able to compare. And then I would have a better feel for what is actually going on, that I could see it. But this bill is relatively simple, and because of that, I will vote for this. But I do have my concerns that have been expressed about, does it cover everything that maintenance, as defined by maintenance, and that is not a well-defined term in my opinion. So I'll be watching future budgets where I think that the maintenance portion has a significant impact, and trust that we're going to see a bill in the hopefully near future that shows us the line items in support of the judicial system. Thank you.
Thank you, gentlemen. Is further debate on the motion? Hearing none. Would the good lady from 32 care to close?
I would. Thank you, Mr. Speaker. I respect that everyone in this room might have a different definition of maintenance. I get that. What is before you today is everything the court system had last year, plus increased costs for insurance, agency fees, and partial CEC, with approximately $450,000 more to come in a future bill. This was well known at the time of the vote in the Joint Finance Appropriation Committee. We had a full day of only having questions about what that meant. And then we voted the following Tuesday. It wasn't until after those passed that I started hearing a lot of different definitions of maintenance, which I would have been happy to consider before, but at the point when we had a bill, we have to do something with the bill, which we are doing today. So nothing has been slipped in to this budget that wasn't there last year, again, except insurance, fees, and increased employee compensation. New computers, new cars, new funding sources, new programs, all will be considered in a future bill. When it comes to replacement items, the request from the agencies this year was $181 million. Perhaps some of you have had a teenager that thinks they need a new phone every time the new model comes out. There might be an agency or two that falls into that category. But even if they do, that is the job of JFAC, to assess and evaluate what to include and what not. Either way, it's new money and new spending. And that's what we're trying to delineate here, is base from growth. You are welcome to look at the legislative budget book on pages 3-66 and 3-67. If you would like to study those line items for yourself, you're always welcome to attend the hearings in JFAC. I agree with some concern I heard about policy committees weighing in. Our practice right now is to have chairmen come and express what the priorities that their committee has identified. But I agree that a flaw in our process is that the public is not allowed to testify on budget bills. Make no mistake, appropriation bills are legislation. They are law. So I hope that's something that we can figure out how to do in coming years as we improve our process by looking at the base and inviting the public to weigh in on budgets and not just state agencies. I again invite you to look at the link of Transparent Idaho on any budget bill that will be before you. The issue of revenue, it occurred to me, I spoke to the good gentleman from 24, and he does recall time. He has 8 years of experience prior to being reelected as a freshman again this year on JFAC, and he does recall actioned a budget setting prior to setting the revenue number. What I can assure you is that we have taken budget action. It took me a minute to remember, but anytime we set a supplemental early in session, we're taking budget action without having identified the revenue number. But we are committed to setting that soon. I share that concern and think we need to do that as soon as possible. Appropriation bills are law, and we work very hard to stay away from the policy space. The good co-chair from the Senate and I have a deep concern about not setting policy in budget bills. If it's an existing program that's asking for an increase, that's a different story. We can handle that in JFAC. But what we do not do is grant money for programs that do not yet exist. That has to happen in the germane policy committees. Mr. Speaker, I think that hits the points I wanted to respond to from the debate, and I ask for your green light on this bill. Thank you.
Thank you, good lady. Debate is closed. The question is, shall House Bill 457 pass the House? Clerk will unlock the machine and the members will cast their votes. Has every member voted? Does any member wish to change their vote? Clerk will lock the machine and record the roll and report the pairs.
Matthias votes nay. Crane 13 votes aye. Ehart votes aye. Gannon votes nay.
38 ayes, 31 nays, 1 absent and excused. The majority having voted in favor of House Bill 457, House Bill 457 has passed the House. Is there correction to title?
No correction to title.
Hearing none, the title is approved. The bill be transmitted to the Senate.
Mr. Speaker.
Good gentleman from 20.
Mr. Speaker, I'd ask you to put the House at ease and we immediately have a caucus.
Gentleman, seconded. House will be at ease.
Hardware and closed captioning for Idaho in Session is provided by the Idaho Legislature and Idaho Legislative Services Office. Additional funding is provided by the Idaho Public Television Endowment. Hardware and closed captioning for Idaho in Session is provided by the Idaho Legislature and Idaho Legislative Services Office. Additional funding is provided by the Idaho Public Television Endowment. and closed captioning for Idaho in Session is provided by the Idaho Legislature and Idaho Legislative Services Office. Additional funding is provided by the Idaho Public Television Endowment.
Foregoing these, the House was in the 11th order of business. The House is at the 11th order of business. Good lady from 8.
Thank you, Mr. Speaker. I ask unanimous consent that we hold all remaining bills on the third reading calendar for one legislative day.
Unanimous consent has been requested to hold all remaining bills on the third reading calendar for one legislative day. Is there an objection? Hearing none, so ordered. The remaining bills be held on the third reading calendar for one legislative day. Without objection, the House now advances to 15th order of business announcements. The House is at the 15th order of business. Good gentleman from 29.
Thank you, Mr. Speaker. Upon adjournment, the House majority will caucus.
Thank you, gentlemen. Is there further announcements? Hearing none, the clerk may read. Nope. Good gentleman, 26.
Thank you, Mr. Speaker. Two quick things. First, the minority will caucus at 3 p.m. And then second, you should have all received an email from our good friends at Ballet Idaho. They are having a performance February 8th through the 11th from 7:30 with a matinee at 2 p.m. on the 10th and 11th. And they are offering us all complimentary tickets. If you would like a complimentary ticket, you can find the email in your inbox, and they will be happy to make that happen. Get a little culture.
Thank you, good gentlemen. And the thought of you in a tutu standing on your toes gives me a Monet. Are there further announcements? Hearing none, the clerk may read.
House Business Committee will meet Wednesday, February 7th, 1:30 p.m., East Wing Room 41, Clow Chairman. House Commerce and Human Resources Committee will meet Wednesday, February 7th, 1:30 p.m., East Wing Room 5, Holtzclaw Chairman. House Judiciary Rules and Administration Committee will meet Wednesday, February 7th, 1:30 p.m., East Wing Room 42, Skog Chairman. House Resources and Conservation Committee will meet Wednesday, February 7th, 1:30 p.m., East Wing Room 40, Mendive Chairman. For tomorrow, House Appropriations Committee will meet jointly with Senate Finance Thursday, February 8th, 8 a.m., Room C310, Horman Chairman. House Education Committee will meet Thursday, February 8th, 9 a.m., East Wing Room 41, Yamamoto Chairman. House Health and Welfare Committee will meet Thursday, February 8th, 9 a.m., East Wing Room 20, Vanderwater Chairman. House Revenue and Taxation Committee will meet Thursday, February 8th, 9 a.m., East Wing Room 42, Monks Chairman. And House State Affairs Committee will meet Thursday, February 8th, 9 a.m., East Wing Room 40, Crane 13 Chairman.
Are there further announcements? Hearing none, House advances to 16th order of business, adjournment. House at 16th order of business.